Hello again, everybody. I'm calling this one I Know Who I Am. Do you? And this one could get a little bit involved. I've tried not to get over everybody's head too much, but unfortunately, I think that we really need to. Forgive the beeping. I've got Discord installed and I can't seem to figure out how to make it not give me notifications. I don't want to uninstall it. So we'll just deal with it. Anyway, I know who I am. Do you? I am the child of a king who is not moved by this world, for Yahusha is with me and goes before me. I do not fear because I am his. Simple. That's who I am. When you figure out that's who you are, things are going to get a whole lot different in your life. A wonderful woman had this pasted on her Facebook page, and I don't have permission to give her name, but her name's Lynette. I'll give you that much of it. But I just saw this and I had to plagiarize it. Let's just put it that way. Okay, we're going to talk a little bit about the Uniform Commercial Code, because this is kind of how they get us. Okay, they made everything commercial, and I'm hoping I can prove this to you. And they operate under something called presumptions. The Uniform Commercial Code can be hard to understand. When you start reading it, it really doesn't make sense if you don't understand law. A little bit. But this is from Cornell Law School, Legal Information Institute. Anybody can go there. Anybody can look this stuff up. But this is 1-206, subsection 1-206. That's what those two little S's on top of each other mean. Anyway, presumptions. 1-206 presumptions, primary tabs. Whenever the Uniform Commercial Code creates a presumption with respect to a fact, or proves that a fact is presumed, or provides that a fact is presumed, the trier of fact, that's the judge or the jury, must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Now, that's interesting because our whole legal system is based upon innocent until proven guilty, and there's maxims of law that talk about how the person who brings a claim has the burden of proving that claim. Yet a judge can take silent judicial notice of a presumption. And when he does that, he shifted the burden of persuasion onto you to prove that that presumption is not true. But yet he doesn't even tell you that the presumption exists because he took silent judicial notice. It's a satanic system, truly. But we're going to go through a couple of things here on the Uniform Commercial Code. I'm hoping I can prove this to you from the law. What's the difference between a presumption and an assumption? Assumption is a noun related to the verb assume. It refers to the act of taking for granted or supposing something. Likewise, presumption is a noun related to the verb presume and refers to a belief on reasonable grounds or probable evidence. Now, they assume and presume all the time, okay, and for all practical purposes these might as well be the same word, because it truly is satanic, and it's based on lies, and it's based on just shafting you by any means possible. It's all about the money. Is the UCC binding law? 1. The purpose of any uniform code is to create a standard body of laws across multiple jurisdictions. The provision of the UCC or any uniform code are not binding on a jurisdiction unless they have been adopted by that jurisdiction. However, the UCC has been adopted in whole or in part by all 50 states. This is from the Uniform Commercial Code and Contracts for the Sale of Goods at lawshelf.com. That's a good site. If you want a good basic education in law, that's a real good place to start. They have courses. You can even get certificates off of that place. A legal presumption is a conclusion based upon a particular set of facts combined with established laws, logic, reasoning. It is a rule of law which allow a court to assume a fact is true until it is rebutted by the greater weight preponderance of the evidence against it. Boy, weight's kind of spelled bad there. Legal presumption of law and legal definitions, U.S. Legal Incorporated. Okay, it's assumed a fact until it's rebutted by the greater weight or the preponderance of the evidence against it. You don't even know that he's taken silent judicial notice. Now, what kind of things does he take silent judicial notice on? Well, first of all, when you go in there, and I'm just going to break some of this down for you, rather than do slides and everything. When you go in there, and you walk through, and he says, "Are you John Smith?" And you say, "Yes, I'm John Smith." He takes silent judicial notice that John Smith walked into the room. Then, at that point, he, or actually the clerk, makes what's called a constructive trust or a resulting trust, and makes the judge, first of all, the prosecutor comes in bringing the charges. He's the trustee, the judge is the executor. Okay, no, I'm sorry, you are the executor, and the judge is the, how's it go? You're the beneficiary, the judge is the executor, the prosecutor is the trustee. The prosecutor carries the liability. And at that point in time, they create joinder between you and this legal fiction that they set up through the birth certificate. And from that point on, he operates under the silent judicial notice of the presumption that you are there to stand as a surety for this dead entity. Okay, and at some point I'm going to explain and break down to you through legal definitions how a birth certificate is really a death certificate. You have a female twin that is dead, is deceased. And that sounds really weird, but it has to do with the fact that the placenta is considered a born alive infant, and it contains your mother's DNA, not yours. So when you get the birth certificate, or you get the certificate of live birth, then sometime after that, after mama takes you home, they put out a birth certificate with an all capital name on it, and that represents the placenta, which is deceased. Then they have a decedent estate, and they somehow, through a doctrine, Brandon's going to cover this next week, I won't hit on it too hard on Big Sib channel, but through the First Testamentary Trust Unum Sanctum, where the Catholic Church, it was Pope Boniface the third or fourth, I can't remember, in 1302, he decided that the church owned everything and everyone. And then there's a series of 3 trusts, followed by a 1666 Sedekah Trust, or Sedekah Act, where everyone is considered lost at sea. So you're presumed dead, because you had until you were 7 years old. You've heard about when a person is gone for 7 years, they're assumed dead. Well, that all goes all the way back to 1666 in the Sedekah Act. And we'll talk about that in a future video too. I'm just laying a little groundwork here. But anyway, through their assumptions and presumptions and their evil and very deceitful trusts, they convert you into a surety for a dead fiction, which basically is the placenta, your mother's afterbirth. That sounds crazy, but it's true and it's provable. Anyway, and then because you don't even know about it, you know you need to rebut it, so you don't. And you go from innocent until proven guilty. At that point in time, you are guilty. And because they have moved you over into equity and you're not in law, the first time you open your mouth to argue anything, you're in dishonor and you've lost. You're not coming with clean hands into equity. So it's quite involved, and we won't get into all that here. But the thing we're talking about now is presumptions and the Uniform Commercial Code. Now, the Federal Rules of Evidence, Rule 301, presumptions in civil cases generally. Well, what's that got to do with the criminal case I'm fighting, or this or that? Rule 301, presumption in civil cases generally, primary tabs. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. but this rule does not shift the burden of persuasion, which remains on the party who added originally. Well, that's a bunch of crap if they're taking silent judicial notice. Bailey, no. Well, that didn't work. I tried to pause this so I could deal with the dog, but so forgive the dog barking. That's my boy. Federal Rules of Civil Procedure, Rule 2, one form of action. And here's how it has to do with your criminal case. In the Rules of Civil Procedure, Federal Rules of Civil Procedure, there's one form of action, okay? And that is the civil action. Everything is civil. They will tell you it's quasi-criminal. They won't tell you it's civil because you wouldn't show up. You'd make them sue you. But they get you in there, and then they get you to be a surety, and then it's over. They've got you. They can take you and hold you hostage and use you through the bonding system. They make up bonds, counterfeit bonds in your name, and that's how they get their money out of this. Well, that's how they get their debt instruments, because there is no money. But that's another story altogether. Okay, Rule 302, Federal Rules of Civil Procedure, applying state laws to presumptions in civil cases. Rule 302, applying state law to presumptions in civil cases, primary tabs. In a civil case, state law governs the effect of a presumption regarding a claim or defense for which state law supplies the rule of decision. Okay, and I just got a little bit of both these rules out. There's a bunch more to it. Mostly all these notes you see down here. These things here, oh, it doesn't highlight. Okay, whoops, it does change though. Those notes go into a lot of the logic behind the statutory construction and all of that. But anyway, we're going back to the Uniform Code for a minute. Uniform Commercial Code. Section 103, construction of the Uniform Commercial Code to promote its purpose and policies. Applicability of supplemental principles of law. A. The Uniform Commercial Code must be liberally construed and applied to promote its underlying purposes and policies, which are 1. To simplify, clarify, and modernize the law governing commercial transactions. Okay, you go into that courtroom, and when you have to, or you've heard the different gurus on the internet talk about how you sign your name without prejudice, or UCC 1-207 or UCC 1-308. That is giving credence to the fact that the Uniform Commercial Code is controlling in that courtroom. Therefore, we can logically deduce that it follows that when you're in there, it's about a commercial transaction. And I'm going to show you that here in just a moment, because everything is civil and it's all commercial. Number 2, to permit the continued expansion of commercial practices through custom, usage, and agreement contract of the parties. And 3, to make uniform the law among the various jurisdictions, unless displaced by the particular provisions of the Uniform Commercial Code. The principles of law and equity, including the law merchant. We're going to get on law merchant here in a little bit. And the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplements its provision. Wow, that's a mouthful. And it doesn't make a lot of sense to the average person. You really have to look at this and break it down to make uniform the law among its various jurisdictions. So in other words, it wants to pull all the jurisdictions in underneath one. And unless it excludes itself, in Part B here it says, the principles of law and equity, including the law merchant. And I forgot to do a slide on this. It's what, inclusio ex, I can't remember the maxim. But include is a limiting term. So when they put including in there, the legal definition means everything else doesn't even matter. They are exercising the law merchant, the lex mercatoria. And we're going to go back to that, and that goes all the way back to Justinian and the 500s AD, and comes up to the present in a more modern form, but it has to do with the corpus juris civilis, or the Roman civil law. So we truly are living in modern day Rome. We are truly the last vestige of the Roman Empire in this end time. And the law relative to capacity to contract. See, there again, it's about contract. It's the relationships between principal and agent, fraud, misrepresentation, blah, 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 blah. But it's all deceptive. It's all designed to be using these trick words like including. Now, including to me is I've got this, this, and this. Oh, and including that. So it means this whole group of things. But when I say I've got this, this, and this, and including that, in legalese, I'm saying the only thing I've got is that. This, and this are excluded. Maybe I'll remember. I'm not real good at remembering this stuff. Maybe I'll look up the maximum law for you before we get over this. So we're going to go through a slideshow here, and then we're going to get on to something different. All crimes are commercial. See 27 CFR, that's Code of Federal Regulations, subsection 72.11, the meanings. And we will probably go look at that here in a little bit. I think I left it up in the browser. Okay, and maybe that's where we'll go right now. I don't remember exactly how I did this. So, that's Lex Mercatoria. Maybe we just go law merchant, rule, one form of action, corpus juris. Okay. And I didn't do that. Okay. Let's go 27 CFR. What is it? 72.11? 72.11, I believe. Yeah, I think this is it. Here, let's go down here to Freedom Law School. They'll have the whole thing there probably anyway. They're a pretty good place. Oh, wow, we get a whole dissertation on it. Okay, well, maybe we'll just read a little bit of this. Have you or a family member been victimized by our so-called legal system? There's help. However, it will not come from an attorney at law, for they are the problem, not the solution. The Citizens' Rights Task Force is here to help. Why? Consider the following facts. According to the late Justice William H. Rehnquist, 100% of people that are in federal or state penitentiaries are there voluntarily. Don't believe it? We have some simple yes or no questions to prove how one is duped into forfeiting their rights and trading them for statutory privileges. An attorney at law is not an arm of the state, and their first duty is to the court, then the government, not you. Furthermore, when any duty to you interferes with their first duty, you are the one to take the back seat. Think you have an attorney-client privilege, where what you say is to an attorney at law remains private? Ever hear of discovery? This is where your attorney is ordered to turn over your information to the state that is attempting to incarcerate you. 1 in 32 Americans is either in prison or on parole or probation. Over 40% of people admitted into prisons in America are convicted under the political code, and therefore by definition political prisoners. Furthermore, since political prisoners end up with mandatory longer sentences, the cumulative effect is that they end up being the majority of the population. America's incarceration rate is now 743 per 100,000, highest in the world. America locks up more people for drug crimes than all of Europe locks up for all crimes combined. If you go to trial in federal court, there's a 96% chance of being convicted. Do you really believe that only 4% are innocent? Is the government's position that if you do not know your rights, then you don't have any? According to 27 CFR 7211, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of weapons, prostitution, extortion, swindling, and many other things like simple addiction to drugs or marijuana use are considered and defined as commercial crimes, where you are converted to an object for commercial use and due process of law becomes a farce. So what's the solution? Learn and exercise your rights. They are yours. Do you know them? They are here to help you, however, in the end, it is you who must stand up for your rights. And we can keep going on this. Let's see if there's anything else I really want to touch on. So, does this have the... Okay. This right here is an excerpt. This is not the whole thing. There's a whole bunch more in here that's not in this. But let me just read this to you. Commercial crimes. Any of the following types of crimes, federal or state. Offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping houses of ill fame, and like offenses, extortion, swindling, confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and the use of marijuana will be treated as if such were commercial crime. Wow. And he says he researched the term commercial crime and found next to nothing in the legal resources available. Oh, it's horrible. It's horrible. It's horrible. But anyway, that's kind of where this Lex Mercatoria. Remember back in our slideshow where the UCC, I think it was 103, I'm not sure. You can look at the video again. And it says, including the law merchant. And what that does is that excludes everything else. Let me go here for a minute and see if I can just find this. Exclusio, is that it? Oh, no, inclusio. Yeah, it's not going to get it. Let's just see if this brings up anything. Oh, there it is. Inclusio unus est exclusio alteris, Latin legal maxim, that makes the point that where a statute, contract, or other legal document includes a list of items falling into a category, the inclusion of certain items on that list should be presumed to mean that any excluded items are intentionally outside the definition. Okay, let's see if we can get a little bit better definition. Merriam-Webster. I'm not seeing any of the ones that I like here, so we'll just go with Webster. And here it is again, if you want to try to learn it in Latin. Come on back here. There you go. Expressio unus est exclusio alteris. A principle in statutory construction when one or more things of a class are expressly mentioned, others of the same class are excluded. Oh, and we're going to have to dig deeper if we want to do it. But this maxim is controlling in this, in the Lex Mercatoria, and they're in the inclusion of the Lex Mercatoria in that list of jurisdictions that basically puts everything under commercial law and contract and under the Lex Mercatoria. So the Lex Mercatoria is the law merchant. Oh, I'm sorry, it said law merchant there, and I'm saying Lex Mercatoria. I didn't tell you that yet. Law merchant. During the Middle Ages, we'll start reading right here. During the Middle Ages, the body of customary rules and principles relating to merchants and mercantile transactions and adopted by traders themselves for the purpose of regulating their dealings. Initially, it was administered for the most part in special quasi-judicial. Now, quasi means it's not, but let's look up quasi. That would be a good word to see, a good definition. Just Q-U-A-S-I. Seemingly, apparently, but not really. Being partly or almost. Wow. Imagine that. So that's what quasi. With that in mind, let's go back to the law merchant here and what we were dealing about. And here it was. Okay, I'm going to just start over. Law merchant. During the Middle Ages, the body of customary rules and principles relating to merchants and mercantile transactions and adopted by traders themselves for the purpose of regulating their dealings. Initially, it was administered for the most part in special quasi, well, not really, but we're going to pretend, judicial courts, such as those of the guilds in Italy and later regularly constituted Piporde courts, have no idea what that word is, in England. See Piporde court, not interested. The law merchant was developed in the early 11th century in order to protect foreign merchants not under the jurisdiction, and actually it goes back to like 5-something under Justinian, but we won't go there. The law merchant was developed in the early 11th century in order to protect foreign merchants not under the jurisdiction and protection of local law. See, lex mercatoria, or law merchant, is foreign, it's international law of commerce. So you're not even in an American court when you go into their courts of law. And they're not courts of law. They're courts of commerce. International courts of commerce. And by the way, the UCC is copyrighted, and we pay like $260,000 a year in royalties to the United Nations for the use of the UCC, the Uniform Commercial Code. And it's instituted worldwide, so it doesn't matter where you go. The UCC is controlling. The Uniform Commercial Code is controlling any country in the world. And it's through the United Nations UNIDROIT Treaty. So it's, like I said, it's convoluted, and I left a lot of stuff out here, but I'm getting to a lot of stuff here too, so you can do your own research. Foreign traders often were subject to confiscations and other types of harassment if one of their countrymen had defaulted in a business transaction. A kind of law was also needed by which traders themselves could negotiate contracts, partnerships, trademarks, and other aspects of buying and selling. The law merchant gradually spread as the traders went from place to place. Their courts, set up by the merchants themselves at trade fairs or in cities, administered law that was uniform throughout Europe, regardless of differences in national laws and languages. It was based primarily on Roman law, although there were some Germanic influences. It formed the basis for the modern commercial law. Okay, did you catch that? Whoops, we got Roman law and is the basis of the modern commercial law. I didn't do a very good job of highlighting there. Let's see, I guess that's all we really want here. Okay, now let's go over here again for a second. And I don't remember if I think I did a slide on this. This is from the Cornell Law School Legal Information Institute. That's where I've taken a lot of the things in the slideshow. It's the Federal Rules of Civil Procedure, Rule 2, one form of action. And this is the short form here. It's Rule 2, one form of action. There is one form of action, the civil action. So when you're taken to court on a criminal action, it's quasi-criminal, which means, well, it's not really, but we're going to pretend it is. And it's truly civil, but they won't tell you that. Okay, this rule modifies USC Title 28, formerly subsection 384, suits in equity when not sustainable. Title 28, blah, 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 conferring power on the Supreme Court to make practices in equity. See, this is all going back to equity. Equity has to do with contract law. It all has to do with contract. Civil, you know, it's contract of the practice in equity. That keeps coming up over and over again. You'll keep seeing that. But these rules are, the states adopt their own sets of criminal procedure, but they follow in lockstep with the federal rules of civil procedure and criminal procedure. But the federal rules of civil procedure, I believe Rule 2 is controlling in most any situation because they're, according to the federal law, there's only the civil action. There's nothing else. Anything else is quasi this or quasi that. And it all is in equity. So it's all dealing with contracts. That's why it's so important not to take this check. You're entering into a contract. If you take that check, see, that's what I should have done. And you know what? I'm going to just go there real quick and we'll come back here. Let's go over here to LAW, whoops, SHELF.com. Okay. Law Shelf Educational Media. Let's see. Yeah, we'll just go to their main page and see if we can get there. Short videos, foundations of law. Let's see what they give us here. Introduction, legal writing, contracts. Let's go to contracts right here. Introduction to and consideration, mutual assent, offer and acceptance, defenses to formation, performance and breach, remedies. Okay, now this place here, Law Shelf, has got these short courses, and like this one here, introduction and consideration, introduction to contracts and consideration, problems and consideration, bargain promises and the mutuality rule, exceptions to the rule, problems and consideration, accord and satisfaction. This is an important term to know. Accord and satisfaction, because when you make an offer to the court, you say, or else, and it'll be considered in full accord and satisfaction. That means it goes bye-bye. But this would be a really good place. This would be a really good place to go look at. And contracts. Let's go over here. The building blocks of a binding agreement: offers, acceptance, consideration, mutuality of consideration. See, so there are 5 actually things that have to be in a valid contract, and the terms of a contract have to be fully disclosed, which is a thing they never do, because they've considered you lost at sea and an infant and a ward of the court, and it's just they're just operating underneath all of these silent judicial notice presumptions under, for all practical purposes, the Lex Mercatoria, which is instituted through the Uniform Commercial Code, instituted under the United Nations Unidroit Treaty. See, oh my goodness, it's like a bowl of spaghetti. It's so convoluted. Okay. Here we're going to look at the Corpus Civilis a little bit. Corpus Juris Civilis. Okay. The Justinian Code, or Corpus Juris Civilis, it was from Justinian I in 527 to 565 CE, aiming to clarify and update the old Roman laws. Okay, we're going to just jump through it a little bit. In 528, he assembled a group of 10 legal experts and 39 scribes to reassess and redo the law. Then if we go down here, and I'm not going to spend a lot of time, Tribonian, now he was big in this, and he was very much involved in bringing this forward, but we end up with the Codex Justinianus, in 529, 12 books containing 4,562 imperial edicts from the time of Hadrian in 117 to 138 CE. See, this stuff is ancient. And Digestum, it was in December of 1533, and I'm just going to go through this. December 1533, 33 and to 565. Okay, and we're going to walk down here. I want to look at where it comes forward. Here we go. Let's go to the legacy. The bodies of law created by Justinian and his experts in one form or another lasted for almost a millennium, until the fall of the Byzantine Empire in 1453. New Byzantine laws were, of course, added to it over the centuries as each emperor issued their own edicts and society evolved. Leo VI 886 to 912, for example, famously produced another collection of Byzantine edicts that had everything translated into Greek, as next to nobody understood Latin anymore. As today, they don't teach Latin. The Corpus Juris Civilis may have failed Justinian's aim to aid his imperial ambitions, but it became the fundamental element of any higher education across Europe from the 11th century and has become the basis for many legal systems ever since. Perhaps he did in the end achieve something of a lasting cultural domination, do you think? The code is a monument to rival his other great achievement, the Hagia Sophia of Constantinople. Roman, then Byzantine laws were, above all, rational, precise, and comprehensive, and it is these qualities which have greatly influenced many of the national and international laws by which we live today. As historian J.H. Rosser wrote, the Corpus Juris Civilis not only preserved Roman law, but provided the basis of law for emerging European nations. Its influences on Western civilization is probably greater than any other book except, of course, the Bible. Wow. So, you don't believe we're under the beast system? You don't believe we're under the Roman system? We're the last head of the Roman Empire? It's talked about in Daniel and Revelation, and yeah, you better start thinking about it. And we have something in our modern law. It's called Corpus Juris Secundum, which literally means the second body of laws. Okay, and what it is a wow. Oh, this is miscellaneous volumes, $95 used. These things, some of these books are $700 to $1,000, $1,500 a piece. But Corpus Juris Secundum, second body of the law, an encyclopedia of United States law at the federal and state levels. It is arranged alphabetically into 430 topics, which in turn are arranged into subheadings. Now, when you do legal research in a law library, unless you're kind of up on what you're doing, the first place you go is to a legal encyclopedia. And Corpus Juris Secundum is kind of not as used as much as it probably should be. I use it a lot, but they've got, each state's got their own. You know, Illinois' got one. Right now the name's escaping me, so it doesn't matter. Anyway, I thought I brought some other stuff up on Corpus Juris. Maybe I didn't. But you notice Justinian's law, Corpus Juris Civilis, and our modern legal encyclopedia, and this is like Moses coming down from the mountain. If it's in Corpus Juris, you can just pretty much bank on it. That's the way it is. You know, but, oops, can't do that. Corpus Juris, he's using the same Latin terms, just one less word. So it's all right there, but you got to dig, you got to know. You got to know what's going on. Now, what do I have here? I think I have something else. This here. Oh, this is the one we pulled up. So anyway, thing is, I'm going to go back into the slideshow here for a minute. I know who I am. Do you? I am the child of a king who is not moved by this world. For Yahusha is with me and goes before me. I do not fear because I am his. When you get that in your mind, when you understand that, when you internalize that, when you make that your own, then things change. Then you understand what's said when Yahusha said, don't fear him who can kill the body, but rather fear him who can kill the body and the soul in hell. Okay? And I probably didn't cite that or quote that just right. But men are a lot less intimidating towards you when you understand who you are, who you truly are, and you have the power. If you understood how much power you had, even without understanding the power that they had, it was only 7% of the colonists who defeated, well, they didn't really defeat, that's another story too, but who won the Revolutionary War, we'll say. will stipulate to that. But 7% against the mightiest army in the world, um, they pretty much knew who they were. They were a lot more spiritual than we are today. And they were definitely not going to live on their bellies. Um, there's a quote from Samuel Adams. I can't say it. I wish I could. I'll put it in the next slide or the next video. But it says basically, if you would like the security of your slavery rather than the animating whatever of freedom, then go from us and bow down and lick the hands that feed you. May our posterity ever forget that you were our countrymen. There's a lot more to it than that. But Samuel Adams, those guys back then, you know, they knew what it was about. A lot more than we do today. We are so dependent upon daddy government, daddy Trump, you know, and then now he's coming out with this check. And I'm so afraid that this check is going to cause a whole lot of people a whole lot of heartache. They're counterfeiting money off of the future labor of your children, grandchildren, great-grandchildren, great-great-great-great-great-grandchildren, because with hundreds of trillions of dollars in derivatives and other debt, there's no way that any generation is ever going to pay that off. They're not going to be able to service the interest with all of the labor of their life. That creates the situation, as talked about in the Bible, where the debtor is slave to the lender. But we didn't voluntarily do that. They tricked us into it. They used this lex mercatoria. They used the law merchant through their UCC and through their fraudulent courts that are ran by these satanic Baal priests, and you can tell they're wearing religious regalia in the form of black robes. That's reserved for military and clergy, okay, to wear uniforms like that. And those particular types of uniforms are reserved for clergy. Okay, so that person sitting up there on that bench, he should be on the same level as you in a common law court. He shouldn't be elevated above you, because all are equal before the law. But yet he's up on that bench and he looks down on you because he's the king and you're the peasant, the peon, the serf, the slave. And then all they do is just railroad you through their system, do whatever they want to, change their rules at will, and if you don't know who you are, you're helpless. Well, they're creating a situation here with this stipend that Congress is arguing about, when they're going to come out with in the second week of April, whatever. They're just working out a way to make our enslavement unbreakable. It's like what they did, the Treaty with Satan video. Go back and look at that again, and look at how slick that offer was of that contract, that treaty. Enter into this treaty, let it control you for the rest of your life. And we believe this, and then down in the notes you see, oh, well, this only applies to nations right now. So Satan made you an offer to contract with you. He's going to do all this with you, but he's not doing that just yet. But sign the offer and it can control you all your life. Oh, and by the way, the trustees can change it whenever they want to. It's all just a bunch of lies. It's a pack of lies. And it's these presumptions and assumptions through the Uniform Commercial Code. So go through here, look these up. Go to this. I don't think it's gonna come up again. But go to the Cornell site, or just put in Uniform Commercial Code, and it'll come up. And go take a look at these. Come back. Go look at 27 CFR 7211. That's going to be on Cornell's Legal Institute, whatever. I don't remember the name. That's going to be on there also. You can look it up there and read the whole thing, because there's a lot more to it than what we've touched on. But all crimes are truly commercial. When you walk into their court, you're walking into an international court of commerce, and everything is contract. Contract makes the law. What's that? Article 1, Section 10 of the Constitution, I believe. I could be wrong. Could be 17. I'm not sure. But you can look it up. Anyway, thank you all once again. And with that, I'm going to say God bless you, or Yahuwah bless you, and give him all praise, honor, and glory. And don't forget your covenant with him so that you can make a bargain with the devil.